Let's continue, members. Mr. Benson Look has some question regarding the last part of the paper, the support for the industry. On paragraph 36 and 37, I have some concerns. I understand that the industry is in general supportive of the bill, and I believe the major organizations are willing to shoulder the responsibility of safeguarding security. And in the response of the administration, it is stated that most of the industries and organizations have no problem with the bill, and if they encounter financial difficulties, those concerned may be SMEs. The administration has pointed out there is a lot of free training and other forms of training for staff. But I would like to know, for the support of the industry, have you ever thought about financial support? For example, for certain organizations of a particular organization, is it possible to have some kind of co-pay scheme? For the SMEs, I think it is burdensome because they got to have a security management plan. They also have to conduct audits and submit audit reports, and they need to conduct a risk assessment. So they may need to hire extra staff. So apart from the training programs mentioned, has the administration ever considered of providing financial support? Deputy Secretary. Thank you, Mr. Lok, for the question. I want to reiterate that the target for regulation under the bill does not cover SMEs because for the critical infrastructure, they are under the major corporations. Well, for the training programs mentioned, they actually cover financial support. For example, I said that the VTC has a new industrialization and technology training program. They supported local companies. If they have to send staff to VTC for training, there may be a cost incurred. And the VTC has a subsidy for that. It is a targeted training program for the staff, but they also provide financial support in the form of subsidies. So for the companies, if they have to send their staff for training, then they have to pay for the fees, but then these fees may be waived. For the digital DIV portal, it is a free program. It is a self-learning package. So if the SMEs have the need to train their staff, they can also save money because it is a free self-learning package. Although we're not dishing out funds, but if you look at the financial aspect, we have been trying to lessen their burden. Thank you, Chair. So let's move on to the follow-up actions from the last meeting. The administration has provided a reply to us. The Secretariat has sent it out to members, and it also has a list of follow-up actions. Paper CB /2 121/2025 /01, and the administration response is in paper CB2 121/2025 So do members have questions on that, or we would need an explanation and introduction of the paper? The paper has been sent to you on Monday. Do you have questions? And do we want an introduction from the administration? Yes, Deputy Secretary, please be concise so that we can make good use of our time for raising questions. Chairman, this paper responds to some of the issues raised at the last meeting. The first part concerns the definition of computer systems. On paragraph B of clause 2.1, it is stated that in Chinese, the word "yatoi" may not be consistent with the English version, a computer. So we want to point out that when we talk about a system, it is something that is formed by the group of systems. For the subparagraph B, we want to point out that if a system, if it is linked with other computer systems, it is also considered as a computer system. So the focus is not on the number of computer systems. So that's why we have not included the word 一台 in Chinese. But for the English version, there is a word a computer. Well, this actually follows the drafting under the English version. And also, according to Cap 1, so if a noun that is a singular, it also covers the plural form. And that's why we think that it is adequate to illustrate our policy intent. The second question is about computer security incidents and computer system threats. It has asked what overseas legislation has been taken into consideration. So we've taken into account the legislation in Australia, Singapore, and UK, and we have set that out in Schedule 1 of the paper. And also we have borrowed some of the terminologies which have been highlighted in gray. But we have not just copied from a certain piece of legislation. We actually look at all the pieces of legislation overseas I mentioned, and we take into account the Hong Kong local situation when we try to describe what is meant by computer security incident and computer security threats. And this is to ensure that we can reflect the situation in Hong Kong. And we also have taken into account certain terminologies used in overseas countries. Under the section, in paragraph 8, we mentioned that when we come to clause-by-clause examination, we can explain in detail. Deputy Secretary, please pause. For Schedule 1, the examples that is included, page 4 of Schedule 1, you have made reference to the UK system, the Network and Information Systems Regulations. When they talk about the concept of computer security, so you are looking at the English version. They use the word availability, authenticity, integrity, or confidentiality. But in our legislation, authenticity is not included. So when you talk about the security status, so we talked about the confidentiality, the availability as well, but why don't we include the word authenticity in our legislation? Well, when we consider this matter, we think that for the current bill, the terminology integrity has been adopted. So integrity will include the concept of authenticity. DOJ, Mr. Leung. Chair, I would like to supplement. We also look at the legislation in the United States, which is not listed in the schedule. They only use the term of availability and confidentiality. For the concept of authenticity, we think that it is included under integrity because integrity has a wider concept. And also when we draft the bill, we have taken into account the views by the Digital Policy Office. And we think that for the IT industry, the terminology used more often are the three words availability, integrity, and confidentiality, which are stated in the bill. And they think that this will be adequate to explain the computer system security. Okay, please carry on. The question is if a certain incident or certain act, whether it is likely to affect the computer security system and cause adverse effect, whether it is a subjective or objective consideration, and who is going to consider that. So I think we have to look at the matter in context, whether it is something objective or subjective. In our response, we have quoted some examples. For example, for Section 28, bracket 1, if an operator becomes aware that a computer system security incident has occurred, so this concerns the CI operator's understanding. So it is the subjective understanding of the CI operator, and it is also a matter of fact. But for the other sections, it may concern that the commissioner has reasonable suspicion that a computer security incident or system has happened. So we have to look at the provisions in context to see whether it is a subjective or objective fact, and who is going to make this decision. When we look at the similar provisions in overseas jurisdictions, they also do not spell out who will be responsible for making that decision to decide what is meant by adverse effect. So I think for this concept, under the different sections, it will appear, and we can consider that in detail later. Then we need to move on whether we need to refine the definition of critical infrastructure. It is now stated that one of the factors is whether it may hinder the maintenance of the critical system. The question is whether we need to define the word hinder. For the definition under Section 2, it is stated that the critical infrastructure includes the damage, loss of functionality, or data leakage, which may hinder or otherwise substantially affect the maintenance of critical societal or economic activities of Hong Kong. So the word hinder has to be taken into account in the context of this section. For Section 2, it is stated that the hinder is whether the hinder is affecting the societal or economic activities of Hong Kong. So whenever there is such a hindrance, no matter the extent, it will have profound implications and should be included. So that's why we consider any form of hindrance, if it can affect the critical societal economic activities of Hong Kong, it should be included under the definition of critical infrastructure, and we do not have to spell out the requirements regarding the word hinder. As to the word of effect, it is wider in concept, and we think that it is necessary to include the word material before that. For number 4, it is stated that for Section 2, bracket 2 to Section 2, bracket 4, it has used some uniformed mentions, and it is asked why it is being done so and why it is different from other legislation. We think that these are actually indicative definitions. It is to give a simple explanation of a complex concept so that it will be easier for us to understand the provisions, and we don't need to repeat the concept time and again. And this is commonly found in other legislation. As stated in Schedule 2, we have pointed out there are certain legislation in Hong Kong which uses similar kind of expressions. Thank you. Thank you, Deputy Secretary. If members have no further questions on the paper, then let's carry on with the clause-by-clause examination. Members, please note that on the 21st of January, the legal advisor has issued a letter to the administration, and the paper is asking the administration about the response to the legal advisor. So we have some follow-up questions that is stated in paper CP2 bracket 136. So the administration will give us some written response in future. So let us please continue with section 4 of the Blue Bill, page C2911. So, legal advisor, when we come across the relevant sections that there is matter that you want members to pay attention to, please let us know. So, who will introduce the bill? I'll ask Ms. Choi to introduce the bill, and if members have questions, the team will be happy to respond. Ms. Choi? Let's start from Section 4. Section 4 is on the functions of the Commissioner. It is a function to identify critical infrastructure and the CI operator, and also to issue codes of practice, to monitor and supervise the computer security threats and incidents, and also to liaise with relevant government departments. Mr. Lai Tong Kwok. Thank you, Chairman. On the functions of the Commissioner, Section 4B, it is stated that the Commissioner may issue codes of practice regarding obligations 1 to 3 of the operators. So for the code of practice to be issued, can it include the later section about the designated authorities, that is the subject operators? Here it is talking about the CI operators. You actually have different terminologies for the operator. The first one is the designated CI operator. So the second time when it appears, you have the term of CI operator without the word designated. And when you come to later sections, Section 6, you have a term called subject operators. So, in Section 4, bracket C, Section 4, bracket B, I think you want to talk about the codes of practice to be issued in respect of categories 1 to 3 obligations of the CI operators. And these are related to the operators who are governed by the Commissioner. So you do not cover the specified operators, the designated authorities. Is that correct? Or do you want to cover everything here under this subsection? Thank you, Mr. Lai, for the question. For subsection 4B, it is a general description of the functions of the Commissioner. We had to see that for the codes of practice to be issued, we may need to look at Section 8 later on. Because for the designated authorities and the Commissioner, they are all regulating authorities and they can issue codes of practice. For subsection 8, I would like to jump to that. So it is saying that if the Commissioner is the regulating authority, then only those CI operators will have to carry out the Category 1 and 2 obligations. So for the other operators, the Category 3 obligation will be governed by the Commissioner as well. But for the regulating authorities, they would have to be responsible for the Category 1 and 2 obligations to be carried out by the operators. So it depends on whether the regulating authority is the Commissioner or the designated authority. So there is a division of responsibility between the two.
Well, the deputations have submitted some views concerning the overlapping of functions. If you look at 4B, just look at 4B on the question of issuing codes of practice. So is the commissioner empowered to issue COPs to cover the organizations regulated by a designated authority? Or if you are saying that you only cover the CI operators regulated by the commissioner, you have to separate the two. Otherwise, when they see two COPs on the internet, and if the two are in conflict, then they have difficulties in deciding which to follow. Well, in B, it says to issue codes of practice in respect of certain category of applications. And also you have the subject operator in clause 6, subject operators. And there are cases whereby there are DAs doing the job, issuing the COPs, such as MA or CA. You need to ensure that there is no overlapping in that. In respect of Category 1 obligations and Category obligations and codes of practice to be issued, they will only be issued by the commissioner. That's the correct interpretation. If that's the case, please reconsider how it is drafted. Of course, under 4A, you have already got the identification of critical infrastructures and designation of CI operators. Otherwise, the subject of your regulation may understand things differently. So I've already ascertained the policy intent behind these clauses. So please go back and consider how this can be further refined to avoid the confusion suggested by the deputations. Maybe can you make some more references in the preceding clauses? Yes, thank you for your suggestion. Perhaps we should consider whether there's any need to designate the matter more precisely, because the 4B is about the functions of commissioner. We have to refer to clause 8 before we can know to which party, to which organizations can the commissioner issue codes of practice. The line is very clear. And also, under clause 8 bracket 3, in the code of practice, the regulating authority should specify the purpose of the code of practice. So I think I should clarify here, when the Bureau introduced the policy intent of bill, there's a catch-all function of the commissioner under clause 54, that if necessary, for sectors regulated by two authorities, the commissioner may perform functions in respect of the CI operators regulated by DA if necessary. Of course, it will be in respect of duties as delineated in the bill. There will be no duplications. All right, so in the future COP, you should specify that this code of practice 0001 will regulate which organizations. You have to specify it. Otherwise, well, especially in the initial stage, people have little knowledge about your work. If that's what you want to achieve, you have to specify that in the core practice, because a core practice is not a piece of subsidiary legislation. So this council cannot ask you to introduce the COP first before introduction. You can issue a core practice anytime you want, and you can revise it anytime you want. So I hope you can address this concern expressed by certain organizations that you have consulted. Thank you, Mr. Lai. Well, actually, we do intend to do something like that. The core practice will cover different sectors, and there may be more than one COP for a sector. So we would specify the purpose very clearly, that this COP is to regulate which organization or which sector. Mr. Ngan Menyu, well, it's a related issue, but I just want to ask something about 6E. To facilitate the Commissioner's performance of the Commissioner's functions under this ordinance, the Commissioner has been empowered to issue a code of practice. It seems that it's not the case that the Commissioner will have to agree with the codes of practice issued by a designated authority. Deputy Secretary, thank you for your question. If we look at 6E, it's not confined to the issuance of code of practice. It's all about the functions of designated authorities, which cover a number of things. One of those is the performance of the Commissioner's functions. We envisage that the designated authorities and the Commissioner would work out something in consultation, coordination with the relevant trade or relevant sector, that in order to achieve consistency under the ordinance, there will be a need to maintain communication with the Commissioner. So 6C is about the performance of the Commissioner's function, which may affect all the 8 sectors, for example. And the 2 designated authorities may need to facilitate the performance of the Commissioner's functions. Instead of asking the Commissioner to invoke the residual power, to catch-all power under Clause 54. So the DAs may issue code of practice to facilitate the performance of the Commissioner. Deputy Secretary, please also refer to 4F, which refers to the Commissioner's duty to coordinate with designated authorities. So apart from facilitation, there's also the need to do coordination by the Commissioner. Mr. Ngan Menyu, Madam Chair, I want to clarify. If a DA, a designated authority, issue a code of practice and the Commissioner does not agree to it, can the Commissioner amend that COP? In that case, the power under 54, Clause 54, would have to be invoked. that would only happen when there's a need to regulate a particular organization under a particular situation. That will not happen frequently. The commissioner will have to be satisfied that certain things have happened. Well, I just want a yes or no answer. We haven't discussed Clause 54. My question is the commissioner empowered to revise or amend the code of practice issued by a designated authority? Yes or no? Or under what circumstances? Well, if these situations described in Clause 54 is satisfied, that can be done. In other words, it's not the situation covered by 6E. It's not about facilitation. We're not saying that one of them can veto or revise the code of practice issued by the other party. Actually, in the performance of the functions, the commissioner will have to be in communication with the designated authority. So we don't think that it will be a routine to invoke powers under Clause 54. So in respect of Category 1 obligations and Category obligations, the commissioner is not expected to revise the code of practice issued by a designated authority. I don't understand. How can the commissioner perform his function under 4B? Because the commissioner are to issue, revise, and maintain codes of practice. I hope the administration would clarify the division of functions to be exercised by the two parties, the commissioner and the DA. Well, in this clause, we are talking about functions of the commissioner and also the functions of designated authorities. So there are two regulators exercising or performing different functions. So under Clause 54, commissioner may perform functions in respect of CI and CI operators regulated by designated authority if necessary, but there are conditions to be complied with. Perhaps you can give us some examples for illustration in writing. Mr. Lai Tong Kwok. I want to clarify two issues. 4G. To perform any other functions imposed or confer on the commissioner under this or any other ordinance. So there are certain functions to be performed by the commissioner under this ordinance. We don't have this commissioner first at present. It would be appointed after the bill is appointed. So if there are new laws to be enacted in the future and you want to empower the commissioner to do certain things, you should do this in that new ordinance. And also, what's the difference of functions imposed on the commissioner vis-a-vis functions conferred on him? There must be some difference because you use two different terms. So my question is, what's the difference between functions imposed and functions conferred on the commissioner? May I ask our law draftsman to respond? Thank you, Mr. Lai, for this particular clause. You can see similar clauses in other laws. For example, interception of communication ordinance, Cap 589, 4B, paragraph 6. and that is to perform functions imposed or confer on the commissioner under this and other ordinance. So the question is, what's the difference between functions imposed on him and functions conferred on the commissioner? From the drafting point of view and the statute law point of view, this is just a standard formulation. So this is just a customary formulation. But it seems that it's rather wordy. There's no need to do this. Well, you talk about impose or conferred on is about obligations and powers. But I think here you're talking about functions, which include both powers and obligations. Am I right? Well, actually, in clause 2, we have a definition. Functions would cover both powers and obligations. You can see this in C2906 for the Chinese version. Functions includes a power and a duty. All right, if we have covered 4, we can proceed to clause 5, designated authorities. And here we have to refer to Schedule 2, and we'll know that which designated authority would be responsible for which sector. For example, MA would be responsible for banking and financial services, and the communications authority would be responsible for telecommunications and broadcasting services. If you look at C3064, and you can see that the regulated authorities under MA would cover authorized institutions and also the relevant store-valued facility operators. As for CA, they will cover telecommunications and licensees and television program service licensee. In an earlier reply to questions raised in the consultation, in deciding whether some authorities will be designated in clause 5, you don't mention the criteria or the factor to be considered. You just mention that the designated authorities are those specified in Schedule 2. Where do we see the criteria for deciding whether certain authorities should be designated as such? Second question, this is related to Schedule 2 itself. In answering this question, Ms. Joyce said something about Part 2 is C3064 or C3065 for the English version, or C3066 for the Chinese version. You talk about designated system. Maybe you can tell us what this is about, orally here if possible, or in writing later.
Thank you, Madam Chair. As for designated authorities, at a policy level, in the Blue Bill, we don't list out all the factors. It has to do with policies, as we have already explained to the Council. If we find it necessary to add more authorities to the list of designated authorities, we may explain to the Council, listing the factors that we will have taken into account. DS, when you amend Schedule 1 and Schedule 2, these are pieces of subsidiary legislation. In the Council, we may adopt negative vetting. Is that correct? Yes. So let's go back to the point ABCD. In Schedule 2 ABCD, first of all, Monetary Authority, column 4, A, an authorized institution. It has reference to the banking ordinance. Cap 155. Well, I'm referring to part 1. C3063 authorized institution has the meaning given by section 2 brackets 1 of the banking ordinance, cap 155. And B, a licensee as defined by section 2 of cap 584. Cap 584 is the Payment Systems and Stored Value Facilities Ordinance. It covers payment tools, as well as stored value facilities. C, a settlement institution of a designated system. Cap 584. Settlement institution has the meaning given by section 2 of cap 584. D, a system operator of a designated system. System operator has the meaning given by section 2 of cap 584. DS. You can tell us more about column 4. Authorized institution. It is a category, or according to the definition, it is a category, but it doesn't mean all the authorized institutions in Hong Kong are authorized institutions as you have specified. In C and D, you refer to settlement institutions or system operators of a designated system, but in fact, not every institution that has been authorized is an authorized institution. We are going to scrutinize clauses 11, 12, and 13. Various conditions need to be met. Is that correct? Yes, indeed. Thank you, Dr. Frankie Yan. The Commissioner doesn't have the right to cancel, to remove, or to amend the list of designated authorities. The administration will have to do so by way of subsidiary legislation amendment. Is that correct? Yes, indeed. It will be an amendment to Schedule 2. Under Clause 70, the Secretary for Security may, by notice published in the Gazette, amend any of the schedules. Legal advisor, can you confirm this is subsidiary legislation? Thank you, Madam Chair. Just now, the administration mentioned, in accordance with Clause 70 of the ordinance, it is confirmed the Secretary for Security may, by notice published in the Gazette, amend any of the schedules, and that will be subsidiary legislation and will have to go by the procedure of negative vetting. The administration may supplement if need be. The legal advisor's explanation is correct. Thank you. Dr. Ban Chan. Am I coming through? Thank you, Madam Chair. In relation to the Communications Authority, C3067A, a holder of a unified carrier license. But some holders of a unified carrier license are multiple holders. I mean, there are holders, but then some licenses are not in operation. Say there is a network provider, but it only serves a small area. Does the commissioner take into account the service area or other factors? Or when a system is idle or semi-idle, in these cases, does the communications authority have the power to make adjustments having regard to the condition of the company or the service provider? Thank you, Dr. Ban Chan. As Madam Chair said just now, in column 4, under monetary authority, communications authority manages telecommunications and broadcasting services, and these are broad categories. It doesn't mean all the holders are subject to regulation. In determining whether the 4 categories of holders are subject to regulation, we will have to refer to the interpretation of the ordinance. We need to see whether the infrastructure is a critical infrastructure. And in Clause 11, ascertaining critical infrastructures, Clause 12, designated CI operators, and Clause 13, designating critical computer systems. Requirements have to be met before an operator is designated as a critical infrastructure operator. For holders whose services have been seized, the communications authority will make a decision as to whether a holder that is not in full operation still meets the requirement as a critical infrastructure operator. So you mean you will communicate with the relevant stakeholders, operators, and you will collect their feedback. Is that correct? Yes, indeed. We've finished scrutinizing Clause 5 in Schedule 2. Any more questions? Any more questions on Schedule 2? Of course. While we were discussing public submissions, you said that you would consider further. So let's move on to clause number 6, functions of designated authorities. Just now we had a discussion on it. The functions are similar to the functions of the commissioner. The functions of DA are similar to those of the commissioner. The difference lies in Category 1 and Category 2 obligations. Mr. Lai Tongkwok. 2 observations, 1 question. Clause 6, C, as I pointed out, to monitor and supervise compliance with Category 1 and 2 obligations. By whom? You didn't specify. A, B, D, you did specify by whom, but regarding C, by whom? This may give rise to confusion. To be regulated by whom? In Clause 4, I asked about G, under this or any other ordinance. The administration gave me a reply. By the same token, why didn't you add under this or any other ordinance in this section? Why? They are similar. So I think you will have to go back and review the drafting of this ordinance. In relation to my question, clause 6E, to facilitate. Dr. Frankie Yan already asked what facilitate means. If the commissioner says that he or she doesn't agree with the designated authorities and needs to make an amendment, and you use the word facilitate, in other words, he or she helps assists the commissioner. He or she doesn't have to listen to the commissioner. So why do you use the word facilitate? Can you use a clearer expression, a clearer word to show the difference between the commissioner and the designated authorities? DS, you said that you had referred to different jurisdictions: commissioner, commissioner's office, designated authorities. The interaction between these parties were mentioned. You may want to cite these jurisdictions. Thank you, Madam Chair. Thank you, Mr. Lai. Regarding Clause 6C, in fact, in brackets A and B, we already mentioned subject infrastructures and subject operators. C actually follows A and B. B refers to code of practice. C rides on B and mentions compliance. That's why we didn't mention subject infrastructures and subject operators in every subclause. We think in A and B we already explained the relevant situation. I'll see if the DOJ has anything to add. In E, we use 利便 in English, facilitate. Why didn't we use a more concrete word, that is to comply with or to obey? The commissioner and the designated authorities have their respective powers under Category 1 and 2 obligations. There is no subordinating relationship between the designated authorities and the commissioner. The commissioner doesn't have to listen to designated authorities. Both designated authorities and the commissioners will be implementing the ordinance. So there will be a fundamental requirement, and there will be collaboration or facilitation between these two capacities. That's exactly why we have the word facilitate. In relation to another question, why wasn't the phrase under this or any other ordinance is used? For example, the Hong Kong Monetary Authority was set up under the other ordinance. That's why 4G serves as a catch-all provision. By the same token, Communications Authority, the case is the same. Just now the DOJ already explained it is a standard provision. That's why we didn't add under this or any other ordinance. I hope my explanation is clear. Let's move on to Clause 7. Regulating authorities may give directions. The operator's compliance with the obligation is defective. Documents will have to be provided. the commissioner can issue written directions in relation to category 1, 2, 3 obligation. 6. For the purposes of subsections 1A, 2, and B2 and 2B, in considering whether a CI operator's compliance with an obligation is defective, the regulating authority concerned may take into account whether the operator has observed a relevant provision in a code of practice. A CI operator that commits an offense under subsection 8 is liable on summary conviction to a fine of $300,000. $3 million, and in the case of continuing offense to a further fine of $60,000 for every day during which the offense continues, or on conviction on indictment to a fine of $5 million, and in the case of a continuing offense to a further fine of $100,000 for every day during which the offense continues. In relation to the word defective, well, I have a question on the Chinese text of the ordinance. In Chinese, it reads 欠妥之處, which in English it means defect. Can you touch up the Chinese text? Well, the text in the Chinese text may sound to be archaic. We want to make it less wordy. That's why we go by the way we draft the Chinese text. This is a drafting process in Chinese. We use 支處 instead of 支地方, which in English both mean places. From the perspective of drafting in the Chinese text, it reads well. I'm not sure if the DOJ agrees that we can amend the Chinese text to make it less archaic. We can make it more modern. Can we use other words, say flaws? Well, we will have to go back and refer to our code, and then we will provide a consolidated response. And this is an issue with the Chinese text. It didn't specify what the defect is. We want to make it more specific. We want to point out what the defect is, and in subsequent provisions, we'll mention or we'll set out the defects, and that is more appropriate.
Ms. Elizabeth Quat. Thank you, Chair Lady. On issues of principle, I would like to clarify something. It is stated in the clause that the regulating authorities may give directions to the operators. So we see the word direction very often. So is there a particular scope for the direction? And have you taken into account the issue of proportionality? And will the impact on the operation of the operator be affected? For example, if the regulators has given some directions, it may give rise to some commercial loss, and then there will be legal disputes, and they may challenge the administration for the reasonableness of the direction. Will such a situation occur? So I wonder whether there will be a clear definition of the scope on direction, and whether the proportionality test has been met. For the directions given by the operator, if the latter thinks that they cannot fulfill it and there will be major impact of them, can they raise objection? And also, is there a time limit for the direction to be complied? Can the operator appeal against the timeline? because you have a daily fine imposed on the operators. But if the operator thinks that the direction is unreasonable, is there a mechanism for appeal?
多謝主席。
Deputy Secretary, thank you, Ms. Kwok, for the question. For the commissioner or the designated authorities, they can give written directions. And these directions are not boundless. Here, we are saying that the operator has to comply with certain statutory obligations. And if they haven't done so, or if the compliance is defective, then they can give a direction. So the scope of the written direction has been defined, and it is not up to the regulating authorities to issue directions one way or another. So this is point number one. Secondly, for the factors to be considered mentioned by Ms. Kwok, if the written directions are to be issued, there will be basic considerations that need to be taken into account. Under the bill, the directions in writing, if the operator is not happy with it, there is an appeal mechanism. The appeal mechanism would cover the written directions. If the operator can ask for a stay of the direction, so we consider that under the bill, Clause 7, the scope of the directions and the protection for the operators and their rights have been duly taken into account, and there is an appeal mechanism. And also they can apply for the direction to be put on hold. Mr. Lai, Chair, I have an observation. On Clause 7, if the director believes, I want to know in Chinese, why do you need the word 则? As Mr. Chen has pointed out, why do we have to write a Chinese version in that way? Even if you do away with the word 则 in the Chinese version, it will be more fluent. If the commissioner believes that A and B subsection has been complied, they can do certain things. The second one is a question. On subsection 5 and 7, it is stated that the regulating authority has the right to revoke the direction. On subsection 7, there are certain conditions laid out, and if these conditions can be fulfilled, the direction can be discharged. So what is the difference between discharge and revoking a direction? What is the difference between the two that you have to spell them out in different subsections, 5 and 7? Administration. Thank you, Mr. Lai. I'll give an initial response and then I'll defer to my colleagues in the drafting section. On the Chinese word 则, our understanding that this is an observation of Mr. Lai. I think this is kind of like a turning point. It is saying that if something has happened, then the commissioner can do something else. But for subsection 5, it is talking about that the direction can be revoked. It is stating that the direction given can be revoked at any time by the authority. If the situations for giving the direction no longer exist. On subsection 7, it is talking about discharging a direction. My understanding is that the regulations or direction has been fulfilled, then the direction can be discharged. So there are specific circumstances under subsection 7. So if the requirements under the written direction has been done, then the direction can be discharged. Mr. Lam? Thank you, Mr. Lai, for your observation. I will try to explain that. For 7, we have talked about subsection 7. We have talked about revoking the direction. And for subsection 7, we talk about discharge of the direction. This is to cover the scenario whereby the regulating authority consider that the fulfillment of the direction is defective. So they will consider whether the implementation details set out in the Code of Practice have been complied with. For subsection 7, when we explained the policy earlier, we said that the COP is not a statutory requirement. Even if the operator does not follow the Code of Practice, if they have other ways to demonstrate that they have fulfilled with the requirements concerning safeguarding computer security, then it is not problematic. For subsection 7, we are thinking of a scenario whereby the regulating authority consider that the operator has not followed the Code of Practice, so they issue a written direction to the operator for improvement. But then the operator may come back to say that they have taken other measures which are in compliance with the requirements. Then it is not revoking the direction. Because to revoke the direction means that the direction has not been issued, it has that effect. But if the regulating authority consider that the responsibility has been fulfilled by the operator, then they can discharge the direction. So subsection 7 is to deal with such a specific particular scenario. It is different from the scenario in subsection 5, whereby the direction will be revoked. Okay, so whether you're going to revoke or discharge the direction, is there any implication on the obligations of the director? When you say it is revoked, it is taken to mean that the direction has not been issued. So if you are trying to prosecute the operator, you're going to do away with the prosecution as well? As for subsection 7, you are saying that the direction is discharged, but you will still carry on with the prosecution. Is that the case? So I would like to know what is the relationship of these two subsections vis-a-vis the prosecutions, if any, regarding an operator. Thank you, Chairman. Thank you, Mr. Lai. I think we have to look at the timeline. For the written direction, unless it has been revoked or discharged, otherwise it is still in force. If there is a timeline stated in the written direction and that has not been complied with, then there is an offense and may lead to prosecution. If we look at the matter that way, we are not talking about that if we want to discharge a direction, we will not proceed with the prosecution process, because within a certain timeline, the direction may be revoked or discharged, then there is no obligation on the part of the operator and no offense has been committed. But if the deadline has been missed and passed, then it will naturally become the commission of an offense, and then we may proceed with prosecution. Mr. Lai, a follow-up question. For such offenses, in clause 7, is it a strict liability offense? DOJ? Well, the legal advisor has raised this issue in his first letter to the administration. The letter dated on the 6th of January. And on the 13th of January, the administration has given a response to that. The relevant paragraph is in the response of the government's response, paragraph 13. So for clause 7, if the non-compliance with the written direction, then our intent is that it will be a strict liability offense. So that means if it has not complied with the written direction within a certain time frame, then an offense has been committed. But there is the due diligence defense. That means the operator has taken all necessary measures to prevent the commission of the offense. And that is stated in clause 65. So there is a defense, right? Yes, in clause 65 there is a defense for such offenses. Legal advisor, anything to supplement? Thank you, Chair Lady. Well, members is clarifying with the administration whether this is a strict liability offense. And we notice that in the government's response there is a detailed explanation. And on the government's response, we have a further follow-up question raised to the administration. We're asking whether there will be extra defenses concerning the strict liability offenses, and we have asked the administration to clarify. But for the moment, the government has not given us a response yet to our supplementary question. Maybe the administration can give members some response at this meeting before they give us a written reply. Would you use reasonable excuse as also be used as the defense? Would the administration has some verbal response at this meeting? We noticed that the question raised is whether the written direction will be discharged under certain circumstances, and for the timeline, when will be the moment for initiating prosecution or not to initiate prosecution. So these are critical moments. If the direction has not been fully discharged, but then prosecution has been initiated, then if we see reasonable excuse defense in the bill, then to a certain extent, then the operator can rely on the reasonable excuse defense as a statutory defense. So we have been discussing this about the discharge of the written direction, and I hope the administration can give us some verbal response concerning our further follow-up questions.
報先，好，唔該主席。好，律政司。
Can we have a short verbal response, please? DOJ, thank you, legal advisor, for the question. Later, we will provide a formal written response, but I can share with you our initial observations. For the responsibilities to be imposed on the operators, we have to decide what defenses should be provided, and it depends on the objective of different legal provisions. Well, in our previous reply to the Legislative Council in paragraph 13, we have stated that we have to think about the legislative objective, and we want to protect the security of the computer security. This is very important because if there is cyber attack, then there will be impact on the societal and economic activities of Hong Kong. So we hope that the CI operators will comply with a more stringent requirement. And we think that it is more suitable to use due diligence defense here. And we don't want to use the reasonable excuse defense because generally reasonable excuse defense will be more lenient. Well, the legal advisor is concerned that under certain circumstances, the operator may not have sufficient time to comply with the requirements in the written direction. Our thinking is that for the design of the bill, it actually allows for mechanism to deal with such scenarios. If the operator consider that they cannot fulfill with the requirements under the time frame stipulated in the direction, they can apply for exemption. They can apply for extension from the regulating authority. And the regulating authorities can give them an extension of time to comply with the requirements. Also, if the operator thinks that the direction is not reasonable or it is not possible for them to fulfill with the requirements in the direction, there is an appeal mechanism. They can go for the statutory appeal board. And this statutory appeal board is meant to deal with situations whereby the operators are not satisfied with the directions of the regulating authorities. The legal advisor has pointed out that in the case of Singapore, the written direction is also being used there. And we note that for the case of Singapore, they use reasonable excuse as the defense. But if we look at the Singapore legislation, the regulating authorities, when they issue written directions, they have a much wider scope to do so. If you look at their provisions, they can issue directions on anything related to their legislation. And also, if there's anything related to the code of practice, they can also issue directions. So the scope is very, very wide there. But for us, there are some conditions that need to be complied with. That is, the authority thinks that the direction has not been complied with or the compliance is defective. So we have some prerequisites set. If we look at the case of Australia and UK, they also do not have used reasonable excuse as in defense under the similar scenario. So we see that there are different practices in different jurisdictions. So the administration thinks that the policy objective is to encourage the CI operators to make efforts to fulfill with the legislative requirements. So that's why they only provide due diligence as a defense. And at this stage, we're not inclined to use reasonable excuse as an additional defense. Well, maybe I'll supplement and then you can clarify. First, in Singapore, the Cybersecurity Act, it is wider in scope because they talk about cybersecurity. Unlike our bill, as we discussed at our first meeting on the policy objective, the administration has never mentioned that the bill concerns cybersecurity. So our bill is more targeted and we only target a critical infrastructure.
So our applications, Category 1 and Category 2, are very specific, and also obligations to be discharged by organizations, and there are requirements to follow the written instructions. So they need to comply by doing certain things, by acting in certain way. So due diligence means that they have done what they can do. But if a reasonable excuse can be different reasons. For example, some explanations as to why certain acts cannot be done. So we're talking about different standard, different threshold. Perhaps you can further elaborate? in the Singaporean Act, the coverage, well, of course, it's called Cyber Security Act, and ours is about critical infrastructure computer systems. Even the Singaporean Act is not about regulating everything related to cyber securities. The key provisions are also related to their critical computer systems and critical infrastructures. But when I talk about the wide scope, because there's the Section 12, if the Commissioner thinks that it's necessary and expedient to ensure cybersecurity on critical information structure, or it's necessary or expedient for the effective administration of this Act, it covers a very wide scope for the purpose of implementing the Act, and for matters which is expedient for the implementation of the Act, they can issue written directions. So here's the difference in scope. In our case, as Madam Chair has said, it would only be a written direction can only be issued if there is a defective compliance or failure in compliance. So, Madam Chair, your observation is correct. And of course, there's a question of difference in the degree of the defense in the form of a reasonable excuse vis-a-vis due diligence. If we adopt a very low threshold by allowing reasonable excuse as defense, it may lead to abuses. Our legal advisor may want to give us some illustration on the understanding of clause 7, bracket 7. It's related to the question raised by Mr. Lai Tong Kwok. Under bracket 7, if an operator has done something to satisfy the written direction, but what he has done may not have been in full compliance with COP. But the regulating authority has not discharged the direction, although something has been done by the operator. The question was whether the prosecution would still go ahead. And even if this is the case, the operator can only invoke the due diligence as a defense. So maybe we should look at other clauses. Clause 65 is to ask the operator to raise a defense that the commission of the offense was due to a cause beyond the defendant's control, and the defendant took all reasonable precaution and exercised all diligence. So in essence, the operator has done everything he can, although not in full compliance with the written direction. Are we saying that in such a case it will be a reasonable excuse? Will the administrations allow the defense of the defendant to invoke the reasonable excuse as a defense? Thank you for your question, legal advisor. In clause 7(1)(b), the notice in writing, or actually in 7(1)(a), is also the same. The written direction has to set out what the operator has to do or has to refrain from doing certain act. So it's not something very abstract, asking the operator to comply with certain section in the law. The requirement has to be action specific. And the operator, CI operator, may be as a matter of ability to do what is required in the written notice. But as in the actual situation, the operator has been doing something else, then we expect the operator to inform the authority, to tell the authority what he has been doing, and then if appropriate, the direction can be revoked or can be discharged. And if not, if the authority doesn't agree, then the operator is required to comply with the written notification or the written direction. And in other cases, the fact that the operator has failed to comply with the direction and the COP is because of the lack of resources of ability. Then they will have to invoke the defense. For example, the operator hasn't got the necessary resources or ability to comply. But if the operator is capable of complying with the direction, but he just chooses to do something else, then he would have to notify the commissioner so that the commissioner can consider whether the direction can be discharged. As for whether prosecution will still go ahead, well, this will have to do with the consideration of the prosecution policy. For example, if the offense is not considered a serious one, then maybe the prosecution should not proceed. Perhaps you can set out in the reply in writing certain scenarios on how Section 7 and Section 75 are to be invoked, because Clause 65 is about the defense. Because under Clause 8 and Clause 9, or Clause 7, bracket 8, bracket 9, there are criminal liabilities. All right, Mr. Benson, look. Madam Chair, I'm concerned about Clause 7, bracket 6. And that is in considering whether a CIA operator's compliance is defective. The regulating authority concerned may take into account whether the operator has observed a relevant provision in a code of practice. Well, the word used here is may. So in considering whether the compliance is defective, one of the standards to be considered is the compliance with the code of practice. Such being the case, what other standards can we refer to in deciding whether the compliance is defective? Thank you, Mr. Look. Well, it's stated here that one of the factors to be considered is the code of practice. As we explained in earlier meetings, the code of practice is not a piece of subsidiary legislation, and is not the only standards to uphold. So in considering whether there is compliance with the COP, we can also consider whether the obligation is complied with through other ways. So while the compliance with the COP can be considered, Even if the COP is not complied with, and if the operator has done something else that would satisfy the direction, then we need to consider whether in such a case we should still issue a notification or direction in writing. So it's just one of the factors to be considered. There are other factors. So COP is just one of the factors to be considered. There are other circumstantial factors. And even if I have to comply with the COP entirely, would you consider other factors in considering whether there's full compliance? Well, here we're talking about issuing direction in writing to see whether the legal obligation is complied with. And in this regard, in considering compliance with an obligation, we can refer to the core practice, which is just a suggested set of standards. Additionally, we have to consider whether the CI operator's compliance is defective, and the factors to be considered will include the COP, but not just the COP. So other factors may have to be considered in deciding whether the compliance is defective. But that's concerning, because we want to make sure that frontline personnel can be sure about compliance. Of course, they would do whatever they can in accordance with the core practice, but there are scenarios whereby compliance with the core practice may not be enough, and there are other factors. The administration should find some way to assure the trade, the operators. I know there's another clause 65, which gives another defense on due diligence. But I think you should find some other ways to assure the people involved. For 7b, bracket 7, bracket B, it's really about a possible scenario that there can be negotiation, because the operator can try to convince the authority to say that he has complied with the obligations. There can be negotiation with the authority to the effect that 7b has been complied with. As I've said, the COP are just some suggested standards, not some hard and fast rules. So in deciding whether the compliance is effective, the authority can decide whether the COP has been complied with, or if this has not been done, whether the compliance has been, the obligation has been complied with through other methods. We are talking about alternative ways to comply with the obligations, or to comply with the standards set out in the core practice. If there are alternatives which have been adopted, then they can be considered. So clause 6.7 talk about that that the regulating authority may take into account the COP, but there can be other factors to be considered. Let me clarify my point. I'm not saying that talking about alternative ways of compliance. But I'm talking about the operator has done everything he can. For example, in the core practice, there are points or steps A to Z which have already been complied with. Would that still be effective? I'm not talking about that the CI operator taking an alternative approach. Well, we have two more members who would like to ask questions. So over to the Deputy Secretary for response first. If you have fully complied with the relevant provisions in the core practice, the regulating authority will not think that the compliance is still defective. And here we're not talking about whether prosecution should go forward or whether the notification should be issued. Whether the core practice is complied with, we have to look at clause 9. If the core practice is complied with, then it can be a factor to consider in compliance. So if a written notification is issued and the CI operator thinks that he has fully complied with the COP, then in a legal proceeding, the compliance with COP can be invoked as evidence in his compliance. So I don't think in such a case the compliance would still be considered defective. I know the bracket 7 is important. If the regulating authority wants to issue certain guidelines or directions, the operator may be concerned because the direction may affect operations. I think 7A and 7B are different in that under 7A, the regulating authority can issue a notice in respect of the CI operators regulated by the commissioner. Oh, but in the other clause we have this subject operator. Here we are talking about an operator other than a subject operator. 7.1a is problematic. The regulating authority will, of course, regulate those organizations under their purview. But does it mean that the commissioner will be barred from issuing a written direction to such organizations? But under 7.1b, for example, for banks, they will not come under the purview of the commissioner's authority. Understand? 2 is about CI operator. A designated authority may in writing direct a CI operator regulated by the authority to do certain things. These terms are not defined in the bill. What's the scope covered? What are they about?
Another question is that I agree with Mr. Ronald Chan in relation to obligations. The operator's compliance with the obligation is defective. So what does defective mean? In Clause 7, Bracket 6, the regulating authority concerned may take into account whether the operator has observed the relevant provision in a code of practice. So I'd like to know what defective means. What is in defect? Because when it comes to law, one either complies or does not comply. You need to let people know what is defective, what is in defect. Regarding Mr. Benson Look's question, when one doesn't think that one is defective, and Madam Chair directed us to Bracket 7, when one does something to improve it, then the direction may be discharged. But in some cases, someone may think that one doesn't do anything defective, so one can appeal. Well, Madam Chair, this is very important. Pardon me. When one doesn't think that one does something defective, under 48, Clause 48, a decision to give a direction under Section 7 is what I mentioned covered under Section 48, Bracket 1A. Thank you, Mr. Ring Kong. Under Clause 7, Bracket 1, CI operator regulated by the Commissioner, and Bracket 2, well, we can refer to the interpretation. Two brackets 4. Well, there is actually a clear guideline. That is operators not regulated by the Commissioner. For operators not regulated by the Commissioner, the Commissioner can check the compliance. When there is defect or when the compliance is defective, a written direction may be issued. And the designated authorities can see whether the operator is in compliance. If not, a written direction can be issued. So while I believe the target is clear, and I'm referring to Bracket 6, may be considered or may take into account, as it is not the only standard. There are 3 categories of obligations, and we accept there are different ways to meet the requirements under the 3 categories of obligations. So we not only take into account compliance with the COP, we also take into account whether an operator has done anything else to meet the requirement under the 3 types of obligations. So what I mentioned is covered under bracket 7. Defective is covered as well. I hope I have answered Mr. Incong's question. Well, I have a question. Just now the DS made a very good point. You already explained what specified critical infrastructure means. So why can't you specify clearly under 7 brackets 1a and 7 brackets 2? You don't have to coin a new noun. Operator regulated by the commissioner or operator regulated by the authority. The more terms you have or the more nouns you have, the more confusing it becomes. Can you use such good definitions of 2 brackets 3 and 2 brackets 4 under 7 brackets 1a and 7 brackets 2? Operator regulated by the commissioner for brackets B. Operator regulated by specified or designated authorities for brackets B. So you don't want to see a new definition whenever it appears. It becomes complicated. Is that what you mean? Thank you, Madam Chair. Thank you, Mr. Incong. Well, I can repeat. Interpretation 2 brackets 4. Critical infrastructure operator. While 4 brackets A, operator regulated by designated authorities, and 4 brackets B, CI operator regulated by the commissioner. So in clause 7, clause 7 brackets 1 brackets A brackets 1, CI operator regulated by the commissioner, you can refer to interpretation clause 2 brackets 4. That refers to brackets 4 brackets B. That's why we use an illustrative interpretation, because in clause 2 we already made reference to that term. We don't have to quote exactly the same term in subsequent provisions. Well, excuse me, Madam Chair. I'd like to make a suggestion. Well, excuse me, Madam Chair. Under clause 2, 4 brackets AB, that is rather confusing. It is not the case that a commissioner doesn't regulate CI operators not regulated by other regulators. In 2.4ab, well, English is very clear. CI operator regulated by the authority. It is very clear. In 4 brackets B, a CI operator regulated by the commissioner. A layman doesn't necessarily go through the entire ordinance. Some probably only reads part of the ordinance, and it may become confusing very easily. Probably the layman may feel that the commissioner cannot regulate a particular CI operator. Mr. Incong was mentioning the room for improvement in relation to drafting. You meant to help people to follow the terms that have already appeared in earlier provisions, but of course you need a context in order to make out the meaning of a particular term. We're up to clause 7. Let's pause right here. We need to discuss whether this is clear enough. Which operator is under the purview of which regulating authority? In relation to drafting, we can ask the administration to supplement. So, Mr. Enkong, has your question been answered? Mr. Dennis Leung. Well, we'll wrap up the meeting only after we have finished clause 7. Let's extend the meeting by another 15 minutes. Seven brackets 5 and 7 brackets 7. One word in 7 brackets 2 is rather important, that is satisfied. You need sufficient evidence and information in order to be satisfied. But in brackets 5, a regulating authority may revoke a direction at any time. And if the CI operator's compliance with an obligation is defective in the opinion of the regulating authority, as the DOJ said, one may not have to follow the COP. One can do something else in order to satisfy the same requirement under the COP. Then a problem arises. When you are satisfied, the regulating authority is really trying to search all information to ascertain that an operator doesn't comply with something. That's exactly why you issued a direction. This may cause discontent among operators. When the CI operator doesn't fulfill all the requirements, you penalize the operator. And when you find some fault made by the operator, then, in this case, however, you don't issue the direction. There's a crisis. So how are you going to handle the crisis? In 7 brackets 1 brackets 2, one is satisfied the operator does not comply with the direction. Isn't there a case that one is satisfied one doesn't comply with anything? Can you draft the legislation in a way that is all-encompassing, a catch-all provision perhaps? Well, in brackets 5, a direction may be revoked at any time by the authority, and it doesn't mean that a direction will be revoked easily. Contextually, the written direction has a time limit within which the operator must do something. If the operator has done something in accordance with the written direction, then the direction may be revoked. This is one of the considerations. This is one of the reasons for the revocation of the written direction. It doesn't mean that after one is satisfied and then when a mistake happens, then you revoke the written direction. It doesn't mean this. At the time of the revocation, the time limit of the written direction has already ceased. The consideration is that one has already followed the written directions. This is one of the factors in the revocation of the written direction. When one has done something in accordance with the written direction, one may not do something exactly as stated under the COP, but the authority is satisfied by what the operator has done, then the written direction may be discharged. That's why they are different. So one discharge, the other revoke. They are different. It doesn't mean that something has gone wrong. Mr. Dennis Leung? So these are two scenarios. Bracket 5 focuses on the time limit within which the operator has done something to the satisfaction of the authority, then the direction may be discharged. And an act may not be exactly the same as stated under the COP. As long as there is an act which makes the authority satisfied, then the written direction may be discharged as well. Well, then bracket 5 can be drafted in a better way. We can make it clear that as long as something doesn't act within a time period, then the written direction may be discharged. Well, as the DS said, this is one of the possibilities, but it is not stated in the law. Then this may give rise to disputes. DS, anything else to add? What I mentioned was just an example for the revocation of the written direction. There may be changes in the situation, and the written direction may have to be updated. There may be other factors in the revocation of the written direction. What I mentioned was just an example. Under the ordinance, the list is not exhaustive. We cannot provide all the scenarios. But it is not the case that there is no regulation. Under bracket 1, under what circumstances may a written direction be issued, and a written direction may be revoked? Under what circumstances? Say the authority has been satisfied, or there may be changes in the situation leading to the revocation of the written direction. So we don't list out all the possibilities or scenarios, but the purpose is the same. We want to bring forth a point that a written direction will not be imposed on the operator for good. There may be changes in the situation, or probably the operator has fulfilled the requirements.
Chair Lady, I hope the administration should go back and see whether these two sections can be drafted more clearly. The administration has explained about subsection 5 and given us an example. Please go back and see if there are other scenarios that you can provide to us in writing. Mr. Ring Kong, the second question has not been answered. You are saying that if the Commissioner is satisfied that the regulation has not been complied with, can you use the form of drafting that you believe that the direction has not been complied with? You are talking about subsection 7. Yes, I'll defer to the DOJ on this. Well, thank you, Mr. Leung, for the questions. For the written directions or the notices, they are based on the assumption the authority believes that there are some non-compliance or breach of the requirements. If we draft it in the opposite direction, then it will be very stringent on the part of the operator, because you're saying that you don't believe that the operator has undertaken all the obligations, and that's why you give a direction. That may be too draconian. So that's why we follow the usual drafting for giving directions and notices, and to show that if the regulating authority is satisfied. Also, the same applies to disclosure, discharge, and revocation of directions. Yes, that's correct, Mr. Ring Kong. As Mr. Lai Tung Kwok has mentioned earlier, to give direction is only the beginning of a process, so the direction in writing is very important. In other parts of the bill, I can see that if the commissioner issue directions or the regulating authorities give directions, they would allow for the operators to make a representation. That means they can give explanation. So before the issue of the written direction, there is opportunity for the operator to give an explanation. And also, the regulating authority will be giving a notice first, unless under some circumstances they cannot give a notice. I mean the issuance of a direction. But before the issuance of the direction, if the regulator can have a meeting with the operator and give an opportunity for the operator to explain the situation, just tell the operator that you are about to issue a direction. This is being practiced elsewhere. Chair Lady, I understand that this cannot apply to all scenarios, but if you allow for that, then it will be very comforting for the operators. They will not be criticized for non-compliance with the directions all the time, because now you are regulating different operators. Can we try to find a middle road so that it will be easy for everyone? Well, we haven't talked about subsection 4, and I now notice that it is stated there that the direction may require the CI operator to revise or resubmit any document. Does that mean that there is a process, there is an exchange between the regulating authority and the operator? So are you allowing them to provide further information before you issue the direction? Is that correct? Chair, Ms. Kong, thank you for the question. A scenario mentioned by Ms. Kong actually falls in line with our policy objective and our intention. For the responsibilities shouldered by the operator, they would have to comply with them within certain time periods, or they may have to provide certain information. If they can't do so, then they will be breaching the requirements. But in practice, we would definitely see why they cannot provide such information and what is the actual situation. So we will not issue a direction right away once after the deadline. We notice that for subsection 7, bracket 1 and 2, we are also saying that we can issue written directions to give directions. So if the operator do not fulfill with the obligations under categories 1 to 3, that doesn't mean necessarily that a written direction will be issued. Ms. Kong has asked whether we would liaise with the operator to understand about the difficulties. These are matters that will be done. During our normal day of work, it is quite common for us when we enforce a legislation, we will not just issue directions once a requirement has not been complied with. This bill is a regulatory bill, and we try to enhance computer security. So we're not aiming at penalizing or punishing the operators. As I have explained earlier, that's not our policy intention. The scenario mentioned by Ms. Kong may happen, but we do not think it is necessary to spell that out in the bill, to state clearly that we have to conduct investigation or understand about the situation from the operator before we issue a written direction, because we know that it is just a matter of course and that will happen during our everyday work. Chair, just a supplement. Well, Chair, thank you very much for bringing out subsection 7 bracket 4. But for subsection 4, the direction has already been issued. It is asking for the provision of document. I want to ask the administration, before the issue of the written direction, can we give a chance for the operator to make a representation? I want to raise this point because this is actually a right under natural justice. When you say that someone is doing something wrong, you should give them the opportunity to be heard. So you should give them a chance to make a representation. If you don't state it in the bill, well, I'm glad to hear the Deputy Secretary said that they will do so, but it is dangerous if you don't spell it out in the bill. For other jurisdictions, they have such provisions. Why don't we have it here? I think because they think that this is very important to ensure that natural justice is being observed. And under natural justice, they should have the opportunity to be heard. So I really hope that the administration should go back and reconsider how to redraft this. If you look at the other jurisdictions, it is stated that the commissioner must consider any objection duly made before giving any written direction. This is very important. I hope the administration would go back and reconsider this. Administration, can you do so? Yes, we'll do so. Because of the matter of time, I'm not going to open discussion on Clause 8. We'll conclude discussion of Clause 7 here. The next meeting will be held on the 6th of February. That will be after the Chinese New Year holidays from 9 a.m. to 1 p.m. It is a 4-hour meeting. Well, thank you, members. Thank you for your hard work and all the best wishes to you for the Year of the Snake. For the administration, can you go back and prepare a written response to the issues and points raised by us at the meeting today? Meeting adjourned. Thank you.